It is the morning the lottery results post, and Wei Chen is staring at a single word on his screen. Not selected. Not because the petition was flawed, not because his employer did anything wrong. His company had built a team around him, filed the H-1B correctly, done everything right. He optimizes the onboard intelligence for autonomous robots working live manufacturing floors, systems where a delay of milliseconds is a safety failure, and a random draw has just decided he might have to leave the country to keep doing it. We are breaking down everything you need to know. Check the timestamps on your screen to jump straight to the segment that impacts you more. Wei is a composite, built from the kinds of cases we see, not a single real individual, but his situation is one we meet constantly. Here's the part he does not know yet, and the reason this episode exists. There is a door out of the lottery entirely, and everything he needs to walk through it is already sitting in his own record. He just has not been shown it. Hold that thought, because we will come back to exactly what the firm saw in his file that he could not. You are watching STEM Meets Immigration from the law offices of Chris M. Ingram. A quick note before we go further. This is general educational information, not legal advice for your specific situation. Stay with us, and by the end, you will understand a two-stage strategy that takes an engineer from a failed lottery to a green card, with no random draw and no employer required.
The world Wei works in. To understand why Wei matters to the United States, you have to understand where his field is heading. For the past decade, the dominant model for artificial intelligence was centralized. A device captures data, the data travels to the cloud runs the model, the answer comes back. That works when you have bandwidth, when latency measured in hundreds of milliseconds is fine, when the cost of a wrong answer is low. Now consider a surgical robot navigating soft tissue in the early hours of the morning, an autonomous vehicle making a lane decision at highway speed in a rainstorm, a drone completing a precision delivery in a warehouse with no GPS signal. None of those systems can wait for the cloud. The intelligence has to live on the device, running in real time, on constrained hardware with power budgets measured in milliwatts and decision windows measured in microseconds. This is Edge AI, and the engineers who can build it, who can compress and optimize neural networks to run at full accuracy on embedded hardware, who can design inference pipelines that make split-second decisions faster than a human can blink, are among the most specialized and sought-after people in technology.
Why the people matter as much as the machines. The demand is not abstract. A global talent shortage survey of tens of thousands of employers across dozens of countries found that AI skills have become the hardest to fill anywhere, for the first time overtaking every other category. Autonomous vehicles, smart manufacturing, drone logistics, medical robotics. Every one of those sectors depends on engineers who can build AI that decides without a cloud connection, and the companies competing for that talent pay accordingly. But compensation does not solve the visa problem. And for engineers from China navigating the US system, the visa problem is one of the most consequential challenges of their professional lives. That is exactly where Wei found himself, and exactly what the right strategy was built to address.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
WEI's story. Wei Chen grew up in Shenzhen, the son of an electronics manufacturer and a mathematics teacher. Technology was the air he grew up in. not just the field he chose. From childhood, he understood that hardware and software were not separate disciplines. They were one conversation about what intelligence could do at the physical edge of a system. He came to the United States on an F-1 student visa to complete a master's degree in electrical and computer engineering, specializing in embedded systems and machine learning inference on constrained hardware. Before he graduated, he had already filed 2 provisional patents on novel approaches to model compression for edge deployment, methods that let complex neural networks run on microcontrollers without meaningful accuracy loss. A leading autonomous robotics company recruited him before he crossed the stage to optimize onboard AI for platforms operating in live manufacturing environments, where a delay of milliseconds could mean a safety failure. His employer filed an H-1B petition. Wei was registered in the lottery. The drawer came back empty.
The moment the frame changed. Now, remember the door from the top of this episode. Wei came to the law offices of Chris M. Ingram through a referral from a former colleague who had been in the same position, and the firm's first assessment changed the entire frame of the conversation. Wei was not simply a qualified engineer who had been unlucky in a lottery. He was an extraordinary ability candidate. He had 2 patent filings addressing a documented technical gap in the field. He had peer recognition from senior researchers at companies operating at the frontier of autonomous systems. He had compensation placing him well above the median for engineers in his specialization. And he had a role of genuine criticality at a company whose platform was deployed in production at scale. His wife May had come to the United States on a dependent visa, and for the first time, the future they were planning had a real legal pathway behind it. As attorney Chris M. Ingram explains, Wei arrived thinking of himself as a lottery loser waiting for next April. We saw something completely different in the same file, an engineer whose record already met the extraordinary ability standard. The lottery was never his only door. For the right profile, it should not even be the first conversation. I'm glad I found Chris Ingram. They helped me tremendously with my EB-1 journey. My primary caseworker, Laura, is highly experienced in handling EB-1A cases. She reviewed my documents thoroughly and crafted strong, well-supported arguments. Thank you for all your efforts in making this a success.
The O-1A, a door that is not a lottery. So what did the firm see that Wei could not, and what did they do with it? The strategy had 2 stages, and the first was the O-1A. The O-1A is a non-immigrant work visa for individuals who have risen to the top of their field in the sciences, business, education, or athletics. It is not limited to academics with hundreds of citations. Industry engineers with strong records of original contribution, peer recognition, and a critical role at a distinguished organization qualify. And critically, it does not go through a lottery. It is petitioner-based, filed by an employer or an agent, but the selection is based on evidence, not a random draw. Wei's evidence mapped to multiple O-1A criteria. His provisional patents addressed a documented gap in real-time inference optimization, original contributions of significance to the field. His role at a company operating at scale established a critical position at a distinguished organization. His compensation placed him in the top tier for his specialization, and peer recognition from senior engineers at frontier autonomous systems companies established that those at the top of his field acknowledged his standing. The O-1A was approved and Wei was back at work, out of the lottery, on a visa that renews on evidence rather than luck.
The EB-1A, from stability to permanence. But the O-1A is a non-immigrant visa. It buys time and stability. It does not by itself deliver permanence. And for a family building a life here, permanence was the goal. That is where the second stage came in. The EB-1A is a first preference employment-based green card for individuals of extraordinary ability. Unlike almost every other employment-based green card, it requires no employer sponsor, no job offer, and no PERM labor certification. The petition is self-filed. The case belongs entirely to the applicant. The standard is genuinely high, either a one-time major internationally recognized award or evidence meeting at least 3 of 10 regulatory criteria, followed by a final merits determination. that weighs the whole record to decide whether the person sits among the small percentage at the very top of the field. Here is the elegant part of the two-stage strategy. The evidence that earns the O-1A is very often the same evidence that founds the EB-1A. The categories are legally independent, but they read from one record. As attorney Chris M. Ingram explained to Wei, the evidence that got your O-1A approved is the same evidence that forms the foundation of your EB-1A. You have already built most of this record. The question now is how to frame and present it to meet the extraordinary ability standard.
How Wei's green card case was built. Wei's EB-1, a petition, was built around 4 criteria: original contributions of major significance, supported by technical declarations from senior engineers describing how his model compression work had changed their approach to edge deployment, a critical role at a distinguished organization, high compensation relative to the field, and peer recognition through invitations to review technical proceedings at 2 international robotics and AI conferences. The law offices of Chris M. Ingram assembled every element with precision. Every expert letter was specific to the criteria. Every piece of compensation evidence was benchmarked against published data. Every technical declaration explained not just what Wei had done, but why it mattered to the field, which is the standard US CIS applies at the final merit stage. The petition was filed, and this time there was no request for evidence at all. It was approved. Wei Chen is now a lawful permanent resident of the United States.
A note on who this applies to. A quick word on eligibility, because it matters, and because the 2 stages have different mechanics. The O-1A is petitioner-based, so it needs an employer or an agent to file, while the EB-1A is self-petitioned and needs no sponsor at all. Both are available regardless of country of birth. To complete the green card, an applicant already in the US in a valid status may pursue adjustment of status once a visa number is available, and an applicant abroad proceeds through consular processing. These pathways assume you are maintaining lawful status or applying from outside. They do not repair a lapsed status. One country note that matters here. The EB-1 category can retrogress for very high-demand countries such as China and India, so where you were born can affect timing. For a Chinese national, the honest framing is that EB-1A is significantly faster than the EB-2 or EB-3 categories, where the weights stretch much further, and it remains the strongest employment-based pathway for this profile. But it is not a no-weight category. Your status, your nationality, and your priority date all shape the route. So the specifics are a conversation to have with a qualified attorney about your own facts.
The action plan, if you lost the lottery or fear you might. Step 1. Document your contributions record honestly and completely, and do not pre-filter. Pull every patent filing, every publication, every conference presentation, every invitation to review or judge work in your field, every performance review that speaks to your impact, every data point on your compensation relative to peers. Most engineers who do this discover their record is stronger than they assumed. Step 2. Identify the people in your industry who know your work and can speak to its significance with authority. The quality and independence of expert letters matters enormously, and those conversations should happen early before you are under time pressure from a visa clock, not the week before a filing. Step 3. Know the specific timeline you are actually on. If you are on OPT, know your STEM extension clock. If you are on an H-1B extension, know your petition status and priority date. If you are on an O-1A, know your expiry window and your parallel filing options. These are not administrative details, they are the boundaries your strategy has to work inside. Step 4. Understand that the lottery is not the only door. If you have patents, peer recognition, high compensation, or a critical role at a significant company, the O-1A can get you back to work on evidence rather than luck, and the EB-1A can build on the same foundation toward permanence. Get an assessment from someone who specializes in exactly this profile, not a general practitioner, and not your employer's HR team. As attorney Chris M. Ingram puts it, The engineers who reach out with runway have more options than the ones who reach out in crisis. A lottery miss is not the end of a plan, it is the moment to start a better one. Move while your status is stable and your record is current.
Wei Chen is still here, still optimizing edge AI systems for robots operating where milliseconds matter. The patents he filed before graduation are active. The work continues, and the family he and Mei are building is no longer organized around a visa clock. The conversation has shifted from survival to planning, where they want to live, what Wei wants to build next, what the future looks like when you are not counting down the days on a document that expires. The companies building the most consequential intelligence systems in the world are competing for a very small pool of engineers who can do what Wei does. Those engineers deserve a visa strategy that matches the value of what they have built. Somewhere right now, an autonomous robot is crossing a live manufacturing floor on an inference pipeline Wei designed. His work is that real. His pathway should be too. One quick question before you go, and we would like your answer in the comments. Keep it general, please, no personal details or case specifics. If the lottery came back empty tomorrow, which part of your own record do you think an attorney could build on? Just tell us the category. A patent, a publication, a role, a recognition. We read them. If you want to see how a lottery miss becomes an O-1A and then a green card, visit breakthroughusa.com. The law offices of Chris M. Ingram has been building these two-stage strategies for engineers at the frontier of their fields for more than 2 decades. No lottery required. And here is where we are headed next. Wei's field lives at the edge of a device. Next time on STEM Meets Immigration, we go all the way to the frontier of the human body itself. The scientists building machines that read thought directly from the brain, and the pathway that keeps them building it here. As attorney Chris M. Ingram says, "You are not waiting for permission to be extraordinary. You already are. Now let us document it." This has been general educational information, not legal advice. For guidance on your own situation, speak with a qualified immigration attorney.